Alright guys, buckle up. Today we're diving into a courtroom where respect for the law runs headfirst into repeat stupidity. Mr. Gregory is back in front of the judge after violating the same charge he was already on bond for, driving without a license. The judge is calm but firm, issuing a brutal reality check and making it crystal clear that his courtroom is not a revolving door. Then comes the cherry on top. A young woman strolls in cursing up a storm in front of a group of school kids on a field trip. Bad idea. She's cuffed and removed within seconds. This courtroom just became the best civic lesson those kids will ever get. Actions meet consequences, real time and raw.
Look, Mr. Gregory, I'm not expecting for you to respond. I'm going to set this case for a pretrial conference on the same date as the other pending cases. You are facing a lot of jail time in these cases, and I don't want to hear any excuses from you today or at any time about why you're driving. I'm fed up with you! Constantly being in this courtroom driving against court orders while pending cases are happening. This is constant, well before Mr. Loftus was ever involved in representing you. If there's one more incident between now and the next pretrial where you come in to this court having gotten another citation, you might as well just walk to the jail. I'm fed up with you. I can't believe I'm letting you go. I can't believe I'm letting you walk out this door. It's constant with you, and I don't get why I keep being so generous to someone who just thumbs his nose at me. Get your client out of here. I don't want to see his face until the next pretrial. Bond is set, $5,000 personal recognizance, not to operate or be in the driver's seat of another vehicle. Thank you, Mr. Law.
Now we shift to a defendant who strolls in casually, wearing his hoodie over his head. Instantly, Judge DeMichelle shuts it down, reminding him that this isn't a basketball court, it's a court of law. The guy claims he's cold, but the judge isn't buying it, especially when he finds out the man has been driving with a suspended license. The judge tosses out his excuse like yesterday's trash. His frustration is visible, and the warning is stern. If you can't take court seriously, you won't be treated lightly. This moment isn't just about dress code, it's about respect, personal responsibility, and how quickly leniency can turn into legal pain.
Okay, Ms. Sullivan, did you understand all of the rights and plea options I just explained to everyone?
Yes.
Do you have any questions regarding any of those?
No.
Do you recall receiving a copy of the
Yes.
citation that was issued on November 1st, 2022?
Yeah.
Okay. You're charged with 2 counts. The first charge is driving under suspension. That is a first-degree misdemeanor. If convicted of this offense, you face a maximum 180 days in jail, a maximum fine of $1,000, and I could impose a license suspension of up to 1 year. And this is a 2-point violation. So do you understand the consequences you face if convicted of that charge?
Yes.
The second charge is use of headlight beams. That is a minor misdemeanor. That is punishable by a maximum $150 fine and court costs. Do you understand that?
Yes.
The officer, I don't know why he checked not applicable on the ticket, but it is very applicable. If you need to provide the court proof of insurance that on the vehicle you were driving on November 1st, 2022. If you're not able to provide this court proof of insurance on the vehicle you were driving that day and are convicted of this offense, you do face a mandatory non-compliance suspension with the Bureau of Motor Vehicles. Do you understand that potential consequence?
What did you mean by non-political, whatever the fuck did you say? What did you mean by non-political, whatever the fuck did you say?
Take her into custody. Did you just use the F word in front of these kids, in front of me? Did you just do that? take her into custody, go down in jail, and then think about what you just said to me in this courtroom in front of these kids, and then maybe, just maybe, I might take your case up later today. Okay? Go. Get out of here.
Sir, come.
Get out of here.
Things escalate when the judge faces another defendant. This time, a man who just can't seem to stop driving under suspension. He's been caught not once, not twice, but 8 times. The judge throws up his hands in disbelief, calling it what it is, ridiculous. What's worse? This guy is somehow surprised he's going to jail. The judge drops the hammer with a clear message. If you keep breaking the law, you'll keep sitting in that holding cell. No lectures, no hand-holding, just cold, unfiltered justice. This isn't just about one man. It's a masterclass in how bad choices pile up and finally catch up.
Case number 25W700388, the state of Michigan versus Bradley Peterson. Okay, counsel, Mr. Perpenwalk Keller, your name for the record, please.
Good morning, Your Honor. Yvonne Parabon Keller, P84328, appearing on behalf of Mr. Bradley Peterson, who is present today in the courtroom.
All right, thank you. And Mr. Peterson, for the record, please.
Agree, Thomas Peterson.
All right, thank you. And Ms. Bella, your appearance for the record, please.
Good morning, Your Honor. Michaela Vella on behalf of the people, P87185.
All right. And so today is the date scheduled for a probable cause conference in this matter. And counsel?
Your Honor, I had the opportunity to speak with Mr. Peterson in the breakout room, and this is something that the court may be aware of, and I am not. Mr. Peterson had recently come out of being incarcerated for the purposes of these proceedings. He got out on bond, and that was arranged. Mr. Peterson and I had discussed a number of things in the breakout room. We discussed going forward with strategy in this case, and Mr. Peterson had informed me that he had filed a motion with the court to remove the judge from this case. And regardless of whether that motion had been filed or not, or whether he intended for such a motion to be filed, I advised him that I was not comfortable with doing so and that I did not agree to do so for the purposes of this case. And as such, him and I discussed that this was going to be a stopping point in going forward with representation. And as such, we parted amicably, and at this time I would ask to be allowed to recuse myself from this case, Judge.
All right, guys. Now we're watching a man try to play it smooth, but the judge's patience is on fumes. This defendant shows up with a long trail of unpaid fines and no intention of fixing the mess. He's asked basic questions, like whether he has a job, and his answers are vague, defensive, and frankly, a little arrogant. But Judge DeMichelle isn't here to negotiate with nonsense. He makes it clear, if you don't want to help yourself, don't expect the court to help you either. It's the kind of no-nonsense justice that reminds us all, dodging responsibility never ends well in front of a judge with receipts.
All right, so counsel, you are asking to be removed from this case because Mr. Peterson filed a motion on his own and not with discussion with you, and you're not comfortable with that motion.
That is not the sole reason, Judge. Mr. Peterson insisted that the only way that he would be comfortable with me representing him in this case is if I continued and persisted with this motion. I do not agree with the motion that he is filing, and he said that he would prefer to go on his own if I would not go forward with this motion in his behalf. And we had a civil discussion about this, Judge. We did not have a fight or anything. I want to make that clear. Mr. Peterson and I have a good relationship, speaking-wise, so I'm not trying to cast aspersions on him at any point. I want the record to reflect that. But this is an impasse that we have reached, and that is the reason I have brought this to the court's attention.
Okay. All right, the court will note that there was a motion that was filed today asking for this court
For the videotape, hearing a bell and charges.
Okay, we don't have videotape. You can request a transcript, certainly. That's Yes, you can certainly request a transcript.
Yeah.
You don't need a motion for that. You can request a transcript without a motion, just so you know.
Okay, well, we did it over Zoom, so I just assumed that you'd have a videotape of it and not a transcript of the 7th, of January 7th, when we had a bail bond discussion and the charges of trespassing and assault in the city of Woodhaven. We did it over Zoom. But
I understand we did it over Zoom, but we don't, that was not recorded over Zoom. It
was just on transcript.
recorded on our transcript.
Okay, well, I'm gonna have to file a motion for that, I guess, because I don't.
No, sir, what I'm saying is that you don't need a motion for transcripts.
Okay.
You can just request a transcript.
Okay, yeah.
There's a fee that you have to pay, but it's not a motion.
Also, I have a request on the Michigan Court Rule 2.003. I believe it's filed that on the 17th on Friday or something like that. So
Okay, hold on, just a moment. Okay, well, counsel, I will allow you to, I will grant your motion to, terminate representation specifically, as far as moving forward, but counsel, I would just, if you can just stay on these proceedings.
Oh, of course, I would sure, yeah, I have no problem.
Let me finish, please.
I'm sorry.
To advise Mr. Peterson appropriately if he's getting into some territory he shouldn't be getting into, okay?
Of course, Judge.
Thank you. So the motion you filed today, sir, is regarding the Zoom video that does not exist, but the transcripts you can certainly request, correct?
yes.
That's all of this one. And we filed something on January 17, and you're requesting under 2.003 to dismiss, qualify the judge as follows. Filed the motion in good faith. Fair bond conditions and restrictions to stop U.S. public protests at the city of Woodhaven public schools are biased favors given to plaintiff. Okay, well, sir, I can tell you that that's not, that's a condition this court put in because that's what's alleged as a violation. So to protect the complaining witnesses, that's what the court put in. Just as in any assault case, sir, I put a no contact provision in. And so that is why I did that, not because there's any bias at all.
Well, if you keep
not at all.
If you keep reading, Your Honor, you'll see that the U.S. Federal Court, Judge Grant, Your Honor, because the city of Woodhaven tried to put a PPO on them, specifically told them, case dismissed, that he cannot.
Now we've got a woman in front of the judge who seems to think skipping court is just a minor oversight. But the judge? He's not amused. He reads off her record like a grocery list of failure. Multiple warrants, missed hearings, and constant excuses. She tries to talk her way out, but every word just digs her hole deeper. When the judge says, "I'm out of patience," you know it's game over. She's ordered into custody on the spot. This is what happens when leniency is mistaken for weakness. The court's done giving chances, and this moment proves that mercy has a deadline.
Please, just 1 moment. I understand that you think that that's the issue. I'm not trying to violate your constitutional rights. What I'm trying to do is that there is, right now, that there's a complaining witness. There are allegations, and so the court, as condition of bond, has put certain parameters and conditions of bond on. Just as, like I just stated, just as if there is an assaultive, somebody with assault and battery or domestic violence, they're not allowed to return to the home or wherever the victim lives. They're not allowed to return to the victim's place of employment. They're not allowed to contact the victim. Those are all conditions I put in. Somebody with disorderly conduct, I put certain provisions in there, whether they can use alcohol or not use alcohol, whether they have to use testing or not testing. It's not intended to violate any rights under the U.S. Constitution. The purpose is for protection of the complaining witnesses and protection of society if this court deems necessary.
That's if somebody violated a law. I haven't violated nothing.
Sir?
I'm with
The allegation is that you assaulted, resisted, obstructed a police officer causing injury and trespassed.
That's just an allegation.
You're correct. But as a condition of bond, there are certain factors the court has to take into consideration when assessing bond, and the court has judicial discretion to assess bond conditions. That is what this court did. I didn't place you on house arrest, told you you couldn't move anywhere. I didn't do any of that, sir. I simply put forth conditions relevant to the allegations therein. And sir, I'm very much aware that they're allegations only.
Yeah, you need to read the whole thing of it, just one. I got like 15 issues in there.
15 issues.
Yeah, you
Okay,
need to read the whole thing. Also, Your Honor, I publicly protested today in front of your court.
Okay.
But none of your police came out to arrest me because that's my constitutional right to do. I'm not ignorant of my constitutional rights. I'm not ignorant. A judge told me a long time ago, ignorance of the law is no excuse.
Right.
And so I studied a little bit. I don't know a lot, but I know my constitutional rights. I've done read your European Constitution over and over again.
All right, now brace yourself, because this next defendant comes in swinging, not physically but with pure attitude. He acts like he's doing the court a favor by showing up. Judge DeMichelle, unfazed, lets him rant, then casually reminds him that court isn't optional. The man's arrogance is peeled away layer by layer until what's left is just someone about to get locked up. This scene is textbook courtroom control. No yelling, no drama. Just calm authority versus reckless ego. If you ever needed proof that confidence without accountability crashes hard, you just found it in 4K.
If I followed your white laws, I follow them, and then you stomp on me when I follow your laws. You've been doing this for hundreds of years. You know, Martin Luther King marched, and you guys
Stop
kicked
right now,
dogs
stop
out.
right now.
You're
I'm
right
not
about
100 years old, so do not accuse me of stomping on anything.
Well,
Let's be very clear on that.
yeah, well, okay. Yeah, don't seem like it.
I'm not 100 years old, sir. Were you interfered with at all while you were engaging in your protest?
My constitutional right? No.
No, you were
I
not.
did at the city of Woodhaven, though, and now you condemning me for it
No,
because
sir.
you restricted me.
Sir, let me be very clear.
I've committed no crime.
I am restricting, I put conditions on for the protection of the complaining witnesses, which is the authority that I've been given with my judicial discretion.
You also
No.
took an oath to uphold every citizen's constitutional right to public protest. But
Okay.
you're not doing that.
Sir, let me clarify. Let me clarify something. There is a balancing act that as judges we have to do. So we have you're charged with a crime, right? It's an allegation. We have the protection of the victim and the community. All right? So there's a balancing act that this court has to do. And that is what this court is doing. I have not restricted all of your movement. I have not said you can't put signs up anywhere. You can't go on any public property. I have not done that, sir.
You did?
No. What I did was I addressed specifically the complaining witness and the victims in this matter. That is what I did, and that is what I have the authority to do that's been given to me by the U.S. Constitution as well. That's statutory authority. Whether you agree with that or not, sir. I understand you don't agree, but that's not a basis for this court to disqualify itself. Let's see what the next one is here. Okay, I don't know what bias favors are. I'm not biased, prejudiced, discriminating against you in any way, sir.
That's your opinion.
And sir, let me just be very clear. The court has not infringed on your First Amendment right of free speech. What it did is it put in protections for the victim in this matter.
I'm the victim.
Which this court has every authority to do.
I'm the victim, and you're not recognizing that. I just protested in front of your courthouse, and it was okay. You should have arrested me then. When I go to your
So
schools,
I don't
I'm
have
your wind out.
arrest
When
warrants.
I go to schools and you're wind out, you should arrest me, but
Sir.
you're not going to.
I, as a judge, do not have the authority to arrest you myself.
Well, they don't either. They took an oath to uphold my civil rights, whether they like it or not.
Sir, did anybody arrest you here?
You weren't supposed to. It's my constitutional right to do. Just like in the city of Woodhaven. This is what I'm trying to get through to you. You're trying to say, no. There's allegations against you that you did this, and this. I'm trying to tell you I exercised my constitutional rights, and they violated me. I'm the victim.
And sir, that is everything that will come through discovery and whatnot. At this stage, this is considered pre-trial.
I know what this is.
So
I've
I
been
don't-
through your system before.
So
Also, Your Honor, I've asked if you don't dismiss yourself, I'm asking for another judge to hold.
Just one moment,
Here.
just one moment, please. This court, sir, has to take the allegations and there's a process.
Like, I don't know it. I know your process. I've been down your roads before. But
I don't know
on
what roads
15,
of mine you've been down, sir.
On 15,
But you've
the
been here,
defendant-
excuse me, you've been here in this court a number of times
Yes,
as
I have.
other matters have been disqualified.
Yes, I
And you
have.
have been treated with respect and fairness. And I believe you've even
that's
stated that
that's not
yourself.
all entirely true.
Hold on, sir, I believe you've even stated that yourself.
Yeah, but that's not all entirely true. You wasn't here to dismiss the posted signs, was you? You should have been here when the prosecutor dismissed City of Woodhaven posted signs.
What?
You didn't show up then.
Hold on, sir, I don't even know what one that is you're talking about.
Well, there was the one that we was going through and postponed. The City of
that
Woodhaven
the
wrote
federal one?
violation. No, they wrote violations on me for posted signs in this case. In other cases. Because I was protesting in the City of Woodhaven.
Okay.
But on that, the day that you were supposed to be here to have that case dismissed, another judge took your place. You think I'm sleepy or stupid, I'm not. But I'm 15.
Stop there right now, sir. Stop there right now.
You do.
I don't think you're sleepy and I don't think you're stupid. When was that case? The one that you're talking about that I had another judge sitting for me, when was that case?
That was, I don't know the exact date of it, but I know the case was dismissed by a prosecutor.
Was that about a year ago, sir?
It was last year.
Last year?
Yeah.
Okay, well, the time that I had somebody sitting here in my place was because I had to go to Illinois on an emergency basis because my father had a stroke.
Oh, my fault.
So instead of having everything dismissed, I made sure I had another judge here to cover. So do not accuse me of thinking that you're asleep. There was a judge here to cover it anyway. So whether I was here or not is irrelevant.
The case got dismissed from the City of Woodhaven. But anyway,
That's
on 15, the defendant under Michigan Court Rule 2.003 requests a hearing by a district court chief judge in case if judge refuses to dismiss herself from this case. I know I have a constitutional right. If you don't dismiss yourself, I have the right for another judge to look at it. This way, it's impartial. It's where another judge can look at it and not just yourself. And apparently, you want to hold this case for a reason. And I believe that you in the City of Woodhaven, the state of Michigan, is in conspiracy. You know what I mean? You guys can say I'm crazy or not, but that's what I'm seeing. Because if you're fighting so hard to keep this case in your court, there's something wrong. Something got to be wrong. You already violated my constitutional right to public protest at the City of Woodhaven because of allegations that I committed assault against the police officer. You guys don't even know me.
Sir, okay, stop right there, please, just one moment. So, I'm not fighting to hold on to this case. I was assigned this case by the State Court Administrative Office. Now, I'm also elected to preside over cases. So, unless there's a valid reason for this court to disqualify itself, I am obligated, whether I want to or not, to sit and preside over the matter. I am the chief judge of this court, and so I don't find that there's a basis at this point for me to disqualify myself. However, you certainly have the right to request the State Court Administrative Office can review that. That's absolutely your right. That's how that gets reviewed.
Well, yeah, I want another judge to look at this, because if you don't want to dismiss yourself from this case, we got a problem right there. Because
There's not a problem, sir. I have a responsibility.
The city would have.
Sir, I have a responsibility. The matter is transferred over to the 27th District Court because the 33rd District Court disqualified itself. Perhaps they sent it here because the other matters that you've had here, I don't know. I can ask for the case to be sent here. It's random. I have zero, just as though when I disqualify myself from a case, it gets sent somewhere else. I have no control over where it gets sent. I have no control over what gets sent to me, whether it's from 25th District Court, 28th District Court, 24th District Court, 34th District Court, or the like, sir.
Well,
So,
I have history.
just so you're aware.
Well, I have a history of this 27th District Court in cahoots with the city of Woodhaven. I think the judge Ken Bash or something like that. He might be up there somewhere. He's retired now. You guys did me the same thing, same way you did.
You guys, I wasn't here.
Well, that's what I'm trying to say.
Here's one for the books. A defendant walks in like it's a family reunion, cracking jokes and grinning like he's on a game show. The judge shuts the vibe down in seconds, reminding him that court isn't a comedy club. Turns out the guy has blown off court dates and now wants to play victim. But Judge DeMichelle is laser-focused. reading him the reality of his situation with surgical precision. There's a shift in the room as the laughs stop and consequences settle in. This isn't just a court appearance. It's a moment of reckoning served cold, without apology or delay.
You wasn't here, you're not 100 years old.
It's not my system. It's the system of the country. It's the entire system. You keep accusing this court that I'm 100 years old and I've been oppressing things for 100 years, that it's my system.
Well, I'm saying
I didn't arrest you. That is not
It's your system,
my system.
and regardless, this is your system, it's not mine.
It is yours. It's
No,
not.
it's not. I'm Native Indian African. I'm not even a citizen.
No.
No, I'm a prisoner in my own country because of you white people. Y'all need to go back home where you guys come from.
Okay, sir. Well, let me just say this. All right. You are accusing this court of being biased and prejudiced.
And racist.
And
Yep.
racist. However, your comment, sir, would seem to suggest otherwise.
Look, why do you raped us, you robbed us, and you murdered us legally?
Stop right
Everything
there.
that you people
Stop
done is
right
been legal.
there. It's not you. I did not do that.
You're the system.
Do not put that on me. But here's what I'm going to do, sir. I'm going to grant your request. And this court's going to disqualify itself, and you can figure out which other court's going to handle this matter. After the state court administrative sends wherever it's got to send, whatever it has to send.
Thank
So, because at this point, I am not going to stay here, take the abuse from you and your allegations, which are completely false and unbased. This court, myself, did not do anything that you're accusing me of doing, at all. I wasn't even around at that point. So we're going off the record. You can step outside in the lobby. Somebody will give you the next stuff you have to do.
And I'll give you a call, Mr. Keller. Thank you very much for helping me.
That's all.
Yes.
There'll be another judge assigned.
So am I free to leave, or do I gotta get paperwork or something?
I believe that you're all set, sir.
Well, thank you. You have a good weekend and a good year. Thank you.
Good luck to you, sir.
'Cause I don't want to violate none of you guys.
In this next case, we've got a defendant who strolls in like the rules don't apply to him, again. He argues with the judge, interrupts, and acts shocked when his past behavior is laid out in brutal detail. But the judge keeps it calm, precise, and absolutely firm. There's no shouting match here, just controlled professional dismantling of a man's excuses. It's clear this courtroom isn't about debate, it's about responsibility. And when you refuse to own yours, the court will gladly do it for you. The gavel doesn't always slam, but the consequences still hit just as hard.
So your case, you're going to get notice in the mail for when your trial date is, and that's going to be with Judge Shackelford, because I did have to recuse myself because you had made threats against me, and I know I didn't feel comfortable with you being in my presence, the case you'll be getting notice of when your case will be heard. All right.
Well, just to clarify, there were no threats made on the record.
So, all right, no, not on the record. You did so on YouTube, and so you're
I say I'm gonna throw truth bombs, like
listen, you put pictures of bombs on me, and the judge is going to find out when things go off or whatever. So you know what? You want to make threats against me? Listen, sir, you would never be able to handle a threat against me. I'm just telling you. Just telling you. So goodbye. Goodbye.
You're believing what?
Bye. So when people make threats against you, I'm just going to tell you right now, and anybody else who's watching out there, I don't take threats very kindly. And you know what? I take them very seriously. And you know what? As a man, as a free man, as a man who is an American, I know what my rights are. And I exercise my rights. Freedom of speech, that's one of them. I like freedom of speech. Freedom of assembly. I like to hang out with people who I like to hang out with. Good people. Good, strong people who are, salt of the earth. People like Mike Tinney. Good friend of mine. I also exercise my Second Amendment right. And I'm well aware how to do so. So, I highly suggest you don't make threats against me. I do have a right to defend myself.
To close things out, we've got a final defendant who thinks ignoring multiple court dates will somehow fix itself. He mumbles excuses, fumbles through explanations, and fails to realize the judge has heard it all before. Judge DeMichelle cuts straight to the chase. He's not here for confusion, just resolution. The message is crystal clear: disrespect the court, and it will respond in kind. This final moment seals the theme of the day. Courts are not playgrounds, and excuses are currency that buys you nothing. Like the video, subscribe to the channel, and we'll see you in the next one.
All right, yeah, this is case 24-2448 SM People versus Eric Martin. And this is a scheduled pretrial conference on the charge of domestic violence.
Good afternoon, Your Honor. Nicholas Tarrant on behalf of Mr. Martin, who appears before us via Zoom. Mr. Martin, if you could state your name for the record, please.
Capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N, family, a private living man, one of the sovereign people.
All right, yeah, this is the pretrial conference. So are you Eric Martin, yes or no?
The living man has been known as not Eric Martin, yes, not the legal fiction corporate entity defendant, though. Spelled out capital letter his name.
Yeah, you're Eric Martin, in other words.
The living man has been known as Eric Martin, yes, not a legal fiction corporate entity, though.
Yeah, Mr. Dillon.
Your Honor, I was recently appointed to this case. The prosecutor just sent me the discovery. Mr. Martin has informed me that he filed a couple motions with the court. I haven't had a chance to review them, but in discussing them with them, one of them I'd be comfortable just asking the court. I think I can do it orally even. Mr. Martin has been incarcerated for about 38 days now, and under the applicable court rule on a misdemeanor case, if he's been incarcerated for 28 consecutive days, he can be released on a personal recognizance bond. I think that that's appropriate in this case. The delay in this case was not any fault of his or anything like that. It's just he's unable to post the bond. So I would ask that his bond be changed to a personal recognizance bond from, I believe it's the $1,000 bond that he has to post. Additionally, I just, like I said, received all the discovery and whatnot. I would need an opportunity to review that. If Mr. Martin would be comfortable wanting to argue his own motions, I have no problem with that. But I have not had a chance to read them, and I would like to know, I wanted to be able to compare them accordingly to the police reports to see what they were. But I do know that just based off of what he's told me, he's been incarcerated for, I believe my count was 38 days. Today will be the 39th day on a 93-day misdemeanor, which would allow for him to be released